Hello everyone and welcome in today's video. I am SOHINI, a third year law student, and currently I am doing an internship at the LEXIS and Company. Today I'll be discussing on the topic of the doctrine of plea of alibi. So what is the plea of alibi? It is the plea of absence of a person or charged with an offence from the place of occurrence at the time of the commission of the offence, and it is named as plea of alibi. The term alibi in Latin word which implies elsewhere or some other place. In the criminal law, this plea is employed by accused against the commission of an alleged offence. When the accused pleads the alibi in court of law, he or she attempts to prove that he or she is elsewhere else at the time when the offence is committed. In other words, it is simply telling us that the accused wasn't present at the time of the crime scene. It's the basic law that in criminal case, the burden is on the accused to prove that he was not present at the scene and has not participated within the crime as per section 103 of the Indian Evidence Act. So as to ascertain the plea of alibi, the accused must lead evidence to indicate that he was too far off at the instant of the crime from the place of occurrence that he couldn't have committed the offence. Section 11 of the Indian Evidence Act 1872 is expounded with the plea of alibi. Section 11 includes two clauses. First, fact inconsistent with the fact in issue or relevancy of fact. One fact inconsistent with the opposite when it cannot coexist with the opposite. Under this clause, facts are relevant only because they can't coexist with the fact in issue or relevant fact. The above example shows that A is illiterate. A cannot write to a defamatory letter to B. These two facts cannot coexist. The usual theory of essential inconsistence is that a specific law cannot coexist with the doing of the act in question, and therefore that if the fact is true of an individual of whom the actual fact is alleged, it's impossible that he should have done the act. Second is facts highly probable or improbable. Under the second clause, the fact which by itself or together with the other fact make the existence and non-existence of the actual fact in issue or relevant fact highly probable or improbable. The word highly probable indicate that the court needs to glide by the prohibits of the circumstances as regards the existence or non-existence of the fact in issue or relevant fact. It also indicates that the connection between the fact in issue and also the collateral facts sought to be proved must be immediate or render the coexistence of the two highly probable. The collateral facts will be admitted in evidence if they create the existence of actual fact in issue highly probable or improbable. What is the scope of Section 11? Section 11 of the Indian Evidence Act is very wide in its application, and it does not impose any restriction on the fact that may be admitted even these facts are highly inconsistent or improbable with the fact in issue or relevancy of fact. The facts which ordinarily tend to render the existence of a fact in issue or relevant fact probable or improbable have relevancy. But under this section, there are collateral facts which by way of contraction inconsistent with the fact in issue or relevant fact are also relevant. It is the only rule of evidence recognized in Section 11 of the Indian Evidence Act that facts which are inconsistent with the actual fact in issue are relevant. The section is described as residuary section copy with relevancy of fact which is logically admissible. Now let us understand with the help of an illustration. A is accused of B's murder on a specific day at Kanpur. Thereon day, A was present at Pune has relevancy to prove the plea of alibi. Now A will prove that it might be impossible for him to commit murder at Kanpur as he was in Pune. Now, what are the essentials of the plea of alibi? Precisely, two essential parts involves the disclosure of plea of an alibi, advocacy and timeline. In general, another factor have to be compelled to adhere as well. First, there should be an alleged offence punishable by law. Second, however, it should be noted that then plea of alibi isn't maintainable in all cases. Number of them are: first, in plea isn't maintainable in civil wrong. For example, in defamation suits, contributory carelessness cases, etc. Second, a plea of alibi isn't applicable in matrimonial cases. For example, suit for maintenance for divorce. Alibi could be a plea of defense in respect to innocence of a defendant by that the accused suggests to court that he was elsewhere at the time of the commission of the alleged offence. Next is the plea should prove on the far side of a reasonable doubt that it is impossible for the defendant to be physically present at the scene of the offence. Next is the plea should be backed by evidence supporting the claim of the defendant. Now, what is the principle behind the plea of alibi? The principle of plea of alibi relies on the Roman principle equi non negat incumbit probation. It means who claims needs to be proved not to the party who negates, and individuals alleged to own done any act might introduce the fact that making it less possible than he or she was present at the time and place of the act, and such facts are admissible even though they don't suffice to form his or her presence totally impossible. Alibi isn't established may be complete defense of the charge of getting committed the crime. The forces of this defense is universally recognized. The principle of alibi is that the essential inconsistent with the presence of the place at and also the time alleged, and thus with personal participation within the fact. Thus the evidentiary fact could be new affirmative proposition considering because the factum probandum through its logical operator is -1. Now, who may take a plea of alibi? Generally, the accused of an alleged offence take the plea of alibi. The accused must plead his presence elsewhere at the time of the commission of the alleged offence. What is the conclusion we can draw? In order for the plea to achieve success and effectiveness, it is always advisable to create the plea at the earliest or within the initial stage of the case. This stage might be the stage of framing charges or at the preliminary hearing. Failure to determine the plea of alibi is a part of the accused to ascertain plea of alibi doesn't help the prosecution, and it can't be held that the accused was present at the crime scene. The prosecution must prove it by positive evidence. Thus, mere failure on the part of the accused to determine the plea of alibi shall not result in an interference that the accused was present at the crime scene. Thank you.